So good morning, everyone. Welcome to the third day of this 5 days workshop on technology transfer in practice. Today, we are again seeing very fresh faces at the start of the day, and I hope we continue it till the end of the day today. We have several exercises today throughout the day, but we start with this first session on licensing deal structuring, and Dr. Richard Cahoon is going to lead this session. We have already introduced Richard yesterday, so I'm going to move on to one introduction about one team member who is joining today for the session, that is Pradnya Aradhye. Pradnya is a registered technology transfer professional, and she currently leads the technology marketing, industry engagement, lead management, and deal structuring initiatives at Venture Center in the Regional Technology Transfer Office. She has successfully supported several ventures in securing government grants and funding. By training, she holds a MTech in Biological Sciences and Bioengineering from IIT Kanpur and brings deep expertise in innovation, commercialization, and startup support. So she's the one more faculty in this session. We have already introduced Dr. Premnath. So with this quick introduction of Pradnya, let us move on to handing over the session to Richard.
Okay. So, Premnath just reminded me that I have a lot of slides, and I know that, and there's a lot of content there, and I used to get stressed out about like, oh no, how am I going to deliver so much information in such a little a bit of time? And I finally just accepted the fact that I've got more information. I mean, it's 30 some odd years of the experiences. I try to distill it down. I'm going to do that today. You will have the slides, and there is more information than I can deliver to you in this short period of time. So the safety valve is that you have the slides, and there's a lot of detail you can go in. When will they have the slides? Will they have the slides? Oh, not till the end. Okay. All right. Well, I hope that I give you, I don't confuse you, and I give you enough to be useful. Again, you'll have the slides. Hopefully I give you enough of a framework that you can find it useful. And apologies for any information that I deliver where you're like, yeah, I know, yes, he's teaching me what I already know, it's already obvious. Apologies for that, that may happen. I just never know exactly what everybody's experience level is. So basically it's just my experience of negotiating, in this case, hundreds of licenses. Most of the, I guess I would say that most of the art, I think, of license deal making is in the exclusive license realm. Now, I know ever since I first started coming to India, when I would say, well, yeah, we all do exclusive, no, you don't do exclusive licenses that much. And so I understand you have a different experience. For us, exclusive licenses are kind of the currency of the realm because we know most of our technologies are early stage and they require investment, usually a rather significant amount of investment. When we have technologies that's ready to go, we often will do non-exclusives. Our plant varieties, for example, they're ready to hand over to growers and nurseries and farmers. So we'll do non-exclusives. And there is an art to that too, but it's, for one thing, it's rather unilateral. We design it, here it is, take it or leave it. Whereas the exclusive license is much more of a developed, and you're going to hear me talk about this, it's a design between the owner, licensor, and the licensee, trying to design this really fine instrument that encourages the implementer, the licensee, to invest serious money, time, effort, get fully behind it, and share with us then the rewards. And I'm going to tell you how I see the license process and the negotiation process. Maybe I'm going to give you a little different perspective of it, as I've learned over time. But anyway, a lot of what I'm going to be talking about is about exclusive licenses. The other thing I want to mention about exclusive licenses, which I think sometimes is lost when in this debate of saying, well, we like non-exclusive because it's more egalitarian, it's more democratic, it's more socialistic. We like that. Spread it out. We have the same intentions. Cornell technology can't be locked up. It has to be made available. This is true of other U.S. universities. It has to be made available. It has to be out there. Our licensees have to be pushing it. They have to be diligently investing, developing, commercializing. And if they don't, we get it back. And we also put in mechanisms for sub-licensing. And there's a lot of push and pressure for them to perform and to make our technologies available for the world. And so we believe that exclusive licenses crafted appropriately will accomplish what you want with a non-exclusive, but have all the beautiful advantages of you've got a licensee that is obligated to invest serious time, money, effort. The value for both parties ratchets way up. So that's why we really like it. So, a little bit about, now, are there some of you, there is this debate, and maybe we shouldn't spend too much time on it, but there is a debate about whether or not we should sell or only license. We only license. We do not sell. If you're a sponsor of research, if you're a private sector sponsor of research at Cornell University, similar at other U.S. universities, ownership is tied to inventorship, not to the funding. So if your big company comes in, puts in a bunch of money for research at Cornell, great, we love that. And if the company says, oh no, yeah, we want to own all the inventions that come out, I'm sorry, that's not our policy or practice. We own any invention made by our personnel in the course of their duties. And they go, well, that's not right. We'll go, well, there are a lot of reasons why we do that. It has to do with sustainability and long-term benefits to the public and for you too. But here's what we can give you is we can license you the rights you need, so don't worry. And it's worked out very well. Yes?
You said ownership is tied to inventorship.
Correct.
And inventor can assign those rights to the funding agency later? And that
Does that
happen?
Well, part of our IP policy, in fact, it's part of our employment policy at Cornell and other U.S. universities. When you agree to be an employee, or if you have a research appointment or a teaching appointment, which you have to work at the university, you have to agree to assign your inventions to the university. So that automatically flows. But in these collaborations between industry and the university, if there are co-inventorship, then there is co-ownership. And we accept that. It's all tied to inventorship. Anyway, why don't we sell? Why do we prefer to license? And there's a set of reasons. I'm not going to go through them now. That's not really the purpose. You'll have these slides, and we could debate them. I know some of you do allow ownership, and I even got into a vigorous discussion with my two colleagues because they said, no, Dick, you've got to change your ideas, because we go to other countries and people say, well, we have to give up ownership. And I say, I understand that. That doesn't mean I have to agree that's a good idea, and I do not. I think long-term, sustainable public sector research institutions should never sell. Yeah.
In this case, how do you look at a tenure prof who is involved in the research, who is the inventor?
Yeah.
Leaving this particular university or an institution and then joining another one. In case of PSRI, it might not be possible, but in universities, somebody might leave after 5 years,
Right.
the inventor. And here, my personal experience with the university is that the leadership of the university was reluctant to go ahead for licensing the technology. Reason being that the prof will go and then who will take the liability of that particular licensed technology?
Yeah, that's always a complexity when particularly faculty move from institution to institution. And that's where Autumn, Association of University Technology Managers, my colleagues, John and Ashley, being a couple of them, if we ever have a situation where one of their faculty comes to Cornell or one of my faculty goes there and we have some situation where, wait a minute, who's the inventor? I mean, did they invent here or there? We work it out. And there's no easy, quick rule about how we work it out, but we work it out. And we work it out in a friendly, collegial, collaborative way. So these are some of the reasons why we prefer to license. This is the most practical one. We were talking about valuation in the room, Premnath and I and Ashley and John, a little bit about valuation. And I've done a lot of valuations. And they can be, to do a really thorough, deep dive where every assumption, every projection is thoroughly evaluated and justified, takes a lot of time and effort. I know because I've spent a lot of time, and most of us don't have that kind of time.
Like you were telling, like if there are co-inventors, we will give for the co-applicants also.
Yes.
What is the ratio of ownership?
Good question. So, and we would deal with this frequently, particularly with other universities. Happens all the time. I get an invention disclosure. First thing I look at is, okay, who are the inventors and what's their affiliation? Oh, Cornell, this person, and this inventor, co-inventor, is at Stanford. Okay, my presumption always is co-inventors are equals, co-ownership is 50-50. That's the way we always start every discussion. Now, I'll talk to the inventors and they'll say, well, you know, it's not exactly like that. It's more like 70-30. If the inventors tell me that, I'm willing to do that. But my presumption always is when I pick up the phone and talk to my Stanford colleagues, we co-own. Now, what happens then, not the purpose of our discussion here, and remember, we have limited time. So that said, what we'll do is one of us has to agree to be the managing partner. So we'll go, well, let's see, should it be Cornell or should it be Stanford? And we make a decision. If I'm the managing partner, I'm the one that acts on behalf of both parties, the two co-owners, and we agree on, we'll share the cost, usually 50-50, we'll share the revenue 50-50. However, we also agree that the managing partner gets a little bit extra. So it's usually a 60-40, something like that, because we're doing all the work.
Even if there are 6 inventors and 5 are from Cornell and 1 is from other university, still it will be...
You mean if did you say there's multiple inventors? Yeah, we will do that. Though we will go to the inventors and say, now they'll get their own share. Well, yes, actually the way it works is that we will usually, the standard default setting is that we'll split it 50-50. Is that fair? Sometimes it isn't. So that's where we'll look to the inventors, and if the inventors want to change the default setting, if they all agree 100%, we will accommodate that. Yeah.
So the one-third rule applies to please
Yes.
use the mic when you're asking. Otherwise
Yeah,
it's
yeah.
captured in the recording.
Yeah, so just now we're kind of veering into
So
IB
if
policy here.
there are, if there are multiple partners, inventors, or 2 of them, then the 1/3 will be divided into 2 of them?
No. So
Okay.
the way it would work, in that scenario I just painted where it's a Cornell, Stanford, it's 50-50. Now, let's exclude that possibility where the inventors go, well, there's 5 of them at Cornell and 1 at Stanford, and that's out of balance. We can accommodate that. But typically what happens is it's 50-50. That's the presumption. 50-50. So we take the lead in marketing and licensing, negotiation. Of course, they're involved. They have to sign the license too. So they're involved in it. Any monies that come in, get split 50-50, but like I say, we take a little bit extra because we're the managing partner, so it's usually 60-40. So 40 goes there, 60 here. Our 60% gets split 1/3, 1/3, 1/3.
Okay.
That
But
1/3, 1/3, 1/3 is only for the Cornell revenue stream, not for other owners.
I think if you don't mind, let's continue with this. Because
Yeah,
we
yeah.
have not finished the-
Yeah. No, I think you're right. So good question, and we can follow up with that later. But here's the thing, is that the reason the reason I prefer licensing, and I've done valuations, and they take a lot of time and effort, it's really hard to arrive at a sale price. I love the license approach, and I'm going to show you why. Because it's an ideal means for the tech creator and owner, that's typically us, and the implementer, the licensee, to fairly share returns and risks. And I do mean fairly. I've got lots of stories to tell, and I better not get into them because that will take up a lot of our time. So I believe that licensing is the foundation of a sustainable tech transfer office and the function. So I'll go to my grave saying we should only license for a whole bunch of reasons, philosophical and practical. So what's our goal? It is tech transfer, right? Is it maximizing return? No. We've said that over and over. It's not maximizing return. It should be a fair and reasonable return. You're going to see more about what I think we are trying to accomplish. But the key here is we want tech transfer. This is not tech revenue maximization. This is tech transfer, okay? Why do we want to transfer it? Well, for technology development advancement. I may have said it, I think I said it, was it yesterday or the day before, where I said, who's our primary client? The technology, right. We want to transfer the technology to serve the public good and the public sector research institution mission. Why do we need to transfer it? Because we can't do it. We have to have a partner. We can't do it, we're not good at it. And it's for a whole bunch of reasons. We need to transfer the rights to our IP so they can commercialize. We have to have a commercializer partner. How are we going to do it? Well, we establish a legally structured partnership, which is the license, okay? So we talk a lot about license, and negotiation, and structure. You're going to hear a different approach or a different way of thinking about this based on my years of doing this. And I have negotiated hundreds of licenses, of IP licenses. The bulk of them at Cornell when I was director. But since that time, with clients and mentees, I've only lost one. I'm proud of the fact that I only lost one deal, and I'll just say real quickly, we got into an early stage discussion with a potential licensee, and on the other side was a young woman, lawyer, and she was like this, like right from the beginning. She, like, okay, I understand why she wanted to take that position, but I'm like, well, that's not my style. I like facts, I like data, I like projections and assumptions that we can verify, et cetera. So she wasn't really ready for that. She just was relatively fresh out of law school. Anyway, at some point, she had taken my template agreement, which was about 15 pages, and it came back, and it was now 50. She had put in so much language. What happens if a pin drops and, there's something that spills on the floor, and she was trying to account for every single eventuality, et cetera. And I just said, look, this isn't going to work. We have to have a certain level of trust with each other. And she goes, well, that's the thing. We don't really trust you. I went, oh, that's a fundamental problem. And she goes, that's right. We don't trust Cornell. Like, oh, well, then we got a lot bigger problem. I think maybe we just shouldn't do a deal. And I said, that's it. I'm not, if you're going to have that attitude right at the beginning. So I lost that one. I walked away. And even the inventor said, yeah, you're right. Let's do something else. So take home message, trust does become a key part of this. Building rapport with we said licenses are marriages. They're like marriages. And a lot of this is that rapport building, the dating. I remember when I first came to India, I would say dating, and people kind of like, what? Because it was a little different process. I think maybe you do a lot more dating now, I don't know, but you know what I mean. It's that rapport building and getting to know each other. You do that in the license negotiation because you'll have your issues later. So this is the kind of the formal way I describe it. A license is wherein the IP creator owner transfers commercial use rights to its IP. I can be very generous there, so you don't need to own it. I can be very generous for you to a commercial partner in exchange for a certain compensation and sharing of rights and obligations. That's the simple description of what a license is. So it's challenging because new IP technology is risky. This is what we all have to accept. And I think we've talked about this. We do have a problem. We all here have an issue that your industry is not that receptive to risk, maybe. And I know that's true in the US. We have, especially in certain industries. I remember, gosh, I'd go to the dairy industry. Those people completely averse to any kind of risk. Old-fashioned, man, to get them to change, really difficult. New IP technology is risky. We're not, TRL, what do we normally have? A TRL, what do you guys work with? TRL 4. Ooh, that's pretty good. 2, 3, we're kind of in that domain. It's like we're trying to convince somebody to take on the risk. It's risky, right? Its value is unproven, uncertain. That's the issue with valuation. We cannot predict with accuracy. It is worth this much. You can come up with parameters, and you'll hear me talk about pre-negotiation valuation, which is doing some homework and establishing, what your IP is, what your inventiveness is, uniqueness, and how that uniqueness confers a performance advantage. So you know your invention, you know the quality of your IP. Do I have a patent? What's its scope? Do I have any trade secret, trademark, copyright, et cetera? So you have a sense of that. You've got a value proposition. I require that we do at least a rudimentary value proposition. You really can't predict how the market's going to accept all this. So you don't know. And so what we have to do is we have to deal with technical risk, business risk, market risk. It's so risky. No wonder those companies run away. But we, through this license, what you're going to see, this art of creating this instrument, we can get them into the mode of like, oh, I see, it is risky, but there could be a really good payoff. And this is how we're going to share risk and return together. And that's what you will do. So it might have significant value or not. So effective licensing, tech transfer, requires that both parties face this fact. And this is what we got to get. We got to get private sector in the room and get them to understand that it's risk, but that's okay. We can manage the risk, and we can work together to develop this instrument that will carry us together through to a point where hopefully we will see some positive returns. How do we do it? Well, first of all, we face the facts of the technology and the IP. That's pretty easy. We can even do that unilaterally, right? We know our inventor well. We know our invention well. We've done a deep dive into inventiveness and prior art. We understand our IP. We understand the technology, kind of how it fits. What we don't know so much is their industry. And what I was saying yesterday to the other group was that I always start my negotiations. They're not negotiations yet. They're just getting to know each other. Remember I said rapport building? The dating process. I start working with my counterpart, licensee, negotiator, and I just start asking questions. I don't talk to them about the technology. I go, I'm really interested in your industry. Tell me about your industry. And I listen, and I listen, and I listen. I ask a lot of questions. I do my own homework, of course, before, if I can. How much time I have, we'll see. But I ask them questions. I go, well, what, tell me about that. I'm curious. I find out about their industry, and then I segue into, oh, tell me about your company. And I'm seriously interested. And one of the things I also say is, look, I'm going to ask you for information because I got to get to know you. It's just kind of like the dating thing. Would you marry someone that you didn't know? No, you got to know them a little bit. What do you think about children? What do you think about, are you really into a lot of money, or, do you care that I drive an old car, sort of thing? So you got to get to know each other. I want to know about their business. And I say, everything you tell me is confidential. And I will use it only for the purpose of helping us together design this beautiful instrument. So this is an art. So you'll see me talk about not you as a negotiator, but I'm going to keep you in suspense for a minute. You have a different, you're putting on a different hat. I'm going to show you what that is. So you face the facts of the technology and the IP. You know that. You don't really know the market, so you listen. Yeah, do your own homework, and I would suggest you talk to other parties, not the licensee, but other parties who knows that industry. Get to know it a little bit, but mostly you're just going to go in with a lot of questions. You listen a lot. Second, by designing an instrument that reasonably, realistically, and fairly shares the value capture and the risk. Okay, so here's the key word. Your designer. This hit me, I don't know how long ago, but now I'm like, yeah, that's what we are, is we're designers of these instruments. And we're not, there's certainly negotiation that happens, but I take a different approach. It's not like, okay, I want this much, you want how much, and we somehow wrestle to a point. I prefer the approach where we say that two professionals who understand IP, who understand their market, who understand business dynamics, etc., let's both sit on the same side of the table here, and let's design an instrument that's going to work for both parties. I want this instrument to allow you to be as profitable as possible. And I get a good share of that, whatever that is. So let's figure out how to design that. And so it's more of an engineering, one might say, problem. And it becomes, then the two of you are working together. It's like, if two engineers or three engineers or a team sit down and go, we got to design a new vehicle or a new plane or something like that. We don't negotiate it. Yeah. There is some negotiation, but it's mostly about design. It's about facts and what's going to be optimal. Okay, so that's the way I approach it. Now, one real quick thing, you'll hear me talk about implementation as well as commercialization. Commercialization is the driver most of the time. We're looking at value proposition, economic drivers, why customers, users will ultimately want the products or services that are covered by our IP. And it's all about profitability at the end of the day. And that is usually what drives us. It's a great framework. But implementation, for those of us who are in the public sector, we have technologies where commercialization, or even the word commercial, is like fingernails on a blackboard. Just a quick example, one of the inventions I assigned my students involved get this, a foot-powered artificial hand. Okay, interesting. Well, my student went and did a lot of good work. She did what she was taught to do. She did all the analysis, the IP analysis, she did market analysis, she did value proposition, and it was one-on-one, which I oftentimes give the student that opportunity. And she starts talking to me about the value proposition and profitability, et cetera, about the artificial hand business, and what are the profit margins there and everything. I'm like, okay, wait, now listen. This invention is actually made in Sri Lanka, and it was invented by someone who was trying to address the need of, 30 years of civil war and terrorist acts that people lost their hands. So are we going to start talking about how do we make how do we maximize our return on that? No, we're talking about implementation. So I say that just so y'all know that in our world, there are times when we have a technology, it's not about commercialization, it's about implementation. Maybe we're going to work with a not-profit entity or whatever. Just don't want that to be forgotten. So, you are a licensed designer. So today is day one of your new career as a licensed designer, okay? And I'm going to tell you about your tools, okay? The license has various mechanisms. Now, how many of you have negotiated a license? Okay. A few, not the majority. How many of you have, at your institution, you have a license template? Okay, so the majority, I guess, not everybody. I do recommend, if you're going to do licensing, get a template. The first place to start, get a template, and they're all, you know, maybe, I don't know, does the Venture Center have access to a good template? Probably does.
We make it available from our collection
Great.
on the Techtransfer Online site.
That's what you want to start with because it's going to be relevant to the Indian context, and you can trust that it's a good start. Then you study it, you get to know it, you tailor it for your institution, you go talk to your legal office and go, okay, let's agree this is going to work. You have that starting point so that you can always, when you start a discussion with a licensee, you have that. The license has various mechanisms for allocating the share of risk and reward. That's what this is all about. You're a designer and you're trying to design this balance. There's risk. Sometimes if it's a TRL2, wow, a lot of risk, but hopefully there's enough potential value if that risk is overcome. Sometimes the risk is, you know, it's TRL5, great, okay, risk is lower. How do we balance that? Between the two parties, the licensor and the licensee. And the ideal balance equilibrates for the potential market value of the technology, and that's where we do this pre-negotiation valuation. I wish we all had time to dive deep and do a, let's say, a very serious valuation of our new technology. At Cornell, I didn't. So busy, so busy. We don't have time, you know, hours and hours. We don't have that kind of time. So here's the reality. When I have a technology and someone comes in who wants a license, I do a little bit of homework to understand the marketplace. I know my technology well. And then I listen with those questions. I listen to them about their industry and about their company and manufacturing and all the context. And then at some point, I'm going to make some presumptions, and then I will make a statement in an opening position for the design, which is my view of what the potential market value of the technology is. But it balances not only for that market value, but the risk that it may not achieve that value, and the investment risk. Boy, is this important. And here's a little trick. Some of the things I'm talking about have to do with how you get deals done, and how was I so successful at successfully completing all these deals with all these different parties, big, small, and in between. Appreciate the risk that the licensee is going to make. They're going to take this risk, they're going to invest capital. And if you do nothing more than acknowledge that they have that. What I normally do is I sit down and go, okay, let's agree on the TRL. That's one of the reasons why I love TRL. You guys use it, that's great. Let's agree what the TRL is. You say 4, and I go, no, I think it's a 3. Let's get on the same page with that, because that's us agreeing on what that risk level is. And then hopefully we don't get stuck on that, because then the next question is, okay, what are you, licensee, going to have to do to take it from a TRL3 to a 4, to a 5, up there to a 9, and sell it? What's it going to take? Let's have an understanding of that. And they go, yeah, well, we'll get back to you on that. Come back and they tell you, wow, that's going to be $1.5 million to take it through those steps. Let's agree. And the inventor is, of course, behind the scenes usually my design, the design studio of the negotiation, let's call it, my inventor's not there. I don't know about you, but my inventor doesn't sit there with me. It's not a good thing. That's my view. But are they involved? Absolutely. So they know what I'm going to go in with, and I come back and I talk to them back in the other room. But I say, okay, let's agree on what you're going to invest to get it from here to there. And I will, here's the key to getting a deal done. Say, I acknowledge the time and effort you're going to put in, and I will factor your investment into my the potential market value of the technology, and then ultimately what you're going to have to pay me. I will factor in this investment risk. And they go, oh, this person cares about the risk we're taking and the amount of money we're investing. I like this. We're building rapport, we're building trust, we're building a working relationship through this process of designing together. And I always go back to this. This is ground zero, inventiveness. Inventiveness is the unique features of our invention, and those unique features, how do we know they're unique? Because we do a prior art search. Do you guys do prior art searches? Yeah, yeah. I recommend, at some level, do a prior art search. Get an understanding of what your inventive features are and what performance advantages conferred. And that's where it all begins, because from that you can go to the value proposition, and man, that becomes just your touchstone when you're doing all this. So I frequently will go back and go, okay, let me go back to the inventiveness where it all began. And then there's this, the economists talk about opportunity costs. So again, if it's an exclusive license, I'm locking up, to some degree, I'm locking up my technology with one party. So there's a cost that has to be somehow incorporated into this balance. I'm not going to talk about this, but this is a diagram.
You keep some time for the license terms, discussion on license
Yeah.
terms, right? So maybe a few slides you can skip and
Okay, yeah, sure. I'm not going to talk about that. This is a diagram of the commercialization process. You'll have that. So these are the terms. These are what I call the moving parts. The moving parts in a fine-tuned value capture risk sharing device. So I didn't call it a license agreement. It is, but I prefer to think of it as this value capture risk sharing device. First of all, scope of the license. First thing, I always sit down and go, what do you need? What do you want? And the licensee, potential licensee says, oh, I want the world. Okay, are you going to be in the world? Well, I'm in India. Okay, well, you're not in the US? No. Well, then why would I license you in the US if you're not going to be there? I've got potential rights there. So I want to give you what you need, no more, no less. So geography, what about field of use? And if they say, wow, what are the different fields of use? Well, we've got dental and maybe veterinary, I don't know, maybe there's several. Okay, well, you want them all? Okay. I don't know how you're going to do that, but tell me how you're going to do that. Scope of the license, field of use. I love field of use licenses because you can give exclusivity to more than one party in different areas. Do you guys ever do field of use licenses? Yeah, they're great when you have a technology that allows you to do that. So, license fee. License fee, typically. And I'm going to tell you typical, okay? And there's always room for, being creative. Although I will say this, you can get really creative. In my first 5 years at Cornell, I got really creative with these beautiful instruments, which was great. And I prided myself on coming up with these wonderful win-win instruments, mechanisms. And one day, one of the contract people came in and said, Dick, I'm looking at this license, we have to monitor it, manage it, and I don't understand what this provision means. And I said, okay, sit down and I'll explain this. So I sit down and I look at it and I go, oh, yeah, what was I thinking? I'm not sure. I had drafted something, I had put in place something that was too complicated to really interpret later. So be careful, be careful. Be creative, but only creative as you need to be. So license fee, typically upfront and non-refundable. And we're not going to talk, well, I guess we can go into, I'll kind of get through to the point of how do you come up with license fee terms, amounts, and I'll try to get to that. Royalty on sales, typically, and for us, exclusive licenses always have these. Always have these two. Royalty on sales, typically percentage of net sales. Can be other, but that's our standard percentage of net sales. Milestone payments. These are beautiful. Milestone payments and minimum annual royalties. And I'll just say this quickly, and there's a whole art to the design of agreements that have milestone payments. You guys know what I mean about milestone payments? Yeah? Do you know the two types of milestone payments? There's two basic types. Anybody want to say? There's time-based, which is you will pay me a payment in 2 years on the anniversary of signing, 3 years on the anniversary of signing. That's time-based. The other is event-based, which is you will pay me a payment on the first successful field trial. You will pay me a payment on the first regulatory approval. What I love about these milestone payments is that it allows the two parties to share risk. So, like I said, these are instruments where you're allocating the risk. If you go to a licensee and say, no, I want it all up front now. They're like, whoa. No, I want all of that money. You're taking all the risk. I want all this. I think the technology is worth this, and I want my percentage of that right now. You're going to have a hard time. That's an uphill battle. But if you say, okay, let's spread the risk out a little bit here. Instead of asking for $500,000 license fee, let me make it $200,000, and then you pay me $150 on the first regulatory approval. See, now I've taken a little bit of risk off of them. That's the sort of thing. Now, I love milestone payments that are based on events because they truly share the risk. They're a little harder to manage. We're going to talk about this at the end of the week, post-signing monitoring. So much easier to monitor contracts where it's just time-based. You put that in your Excel spreadsheet and it pops up. If it's an event, a little harder to track that, but I love it. Minimum annual royalty is a really powerful tool as well, and we don't really have time to go into the details of it, but basically what it is, the way I do it is I sit down in that rapport building with the licensee. I say, okay, yeah, now when do you think you're going to have that first sale? You go, yeah, well, I think a couple of years. I think we're going to be ready in 2 years. We can have that first sale. Great. Now, what I'm going to do then, and we've agreed on the license royalty rate, and we've agreed on what their projections of sales. I will have asked that, and they will, we've gone back and forth on projections. So I can then predict, together we can predict with some level of accuracy, we hope, on what royalty they would owe us. And so then what I say is, okay, you should be able to pay me, let's say it's $25,000, and we ask for it at the beginning of the license year, and then we go through the year, and you're selling and you're collecting royalty, and at the end of the year, you look and see, do you owe me $25,000 at the end of the year? So then you've prepaid it. You don't owe me anymore. It's a great tool to force them to go out there and push and sell, because then the customer essentially pays the royalty. But if they don't, if they only, maybe only 10,000 worth, the other 15, they got to just pay me. It's what I call the price of exclusivity. But what I'll say is, okay, and this is where my generosity, this is another little trick of the trade, and that is, whenever possible, I like to be generous, because especially at the outset. Now look, like, no, I'll be easy. Because later on, you probably want to get a little harder. And so it gets a lot easier to be harder initially, I think. This is my style. So what I will do is I'll say, okay, when are you going to have that first sale? Anniversary of second year? Perfect. Tell you what, I'm not going to ask you to pay a minimum annual royalty payment until the beginning of year 3. So you're going to be out there selling, and I'm not going to put any pressure on you until the next year. See, you know why? Because I've been down that road of product development and sales, and I know how hard it is to meet those tough deadlines. So, and we want to be a good partner for you. We want to be, we want to, we'll have a good deal, but we also understand. So that's how I do it. Sub-licensing rights, I always include this as part of the design. I don't automatically include it. Sub-licensing rights are always something to be negotiated. Is it going to go in or not? And we have ways to use the sub-licensing rights that help us. This is one of the ways we take an exclusive license and make it more broadly available. Like we were talking about non-exclusives, the reason we like non-exclusives is because we don't have to give a preferred license to one entity. We can license everybody. Well, the sub-licensing mechanism is a way to have an exclusive licensee but provide incentives and disincentives to get the exclusive licensee to sub-license out in different geographies and just in general. And we can do revenue sharing of the sub-license revenues. That becomes one of our little design tools. Future IP, what happens to future IP? That's another design tool. So future, I'll just very quickly tell you, if the licensee has a license to some patent, and we know the scope of the patent because of the claims. How many know claims? You know claims, okay. So I think of claims as an umbrella, and that defines the scope of what's inside that license. What rights are we giving to that technology? There's the umbrella. And if they fund work, more work at the institution, an invention comes out and it would fall under that umbrella, I'm easy. I just go, it just flows in. I can't license it to anybody else because it's already dominated by their licensed patent, the one they have. So I'll just put in the agreement that any future invention that would fall under the license umbrella just flows in easily as an amendment. But if it falls outside, subject to a separate negotiation. That's the way I handle it. It's worked really well. But future IP is an important one to consider. IP costs, who spent exclusive licenses for us, always the licensee pays all of our patent expenses for those countries where it has rights. And who's going to enforce it and transfer, I'm not going to talk about that now. So these are all the different moving parts that allow us to design this risk sharing value capture allocation. Scope of license, what are you transferring? What's the IP, the field of use, geography? License fee, it's that guaranteed compensation. I tell them, you're never going to get that money back. So that's our guaranteed compensation for entering into this transaction. Now, one thing about license fee is I frequently will be creative with how the license fee is paid. So $500,000, I'm going to have to go to the board to sign that. Well, what is your signature authority? It's only 250. Oh, okay, well, I'll tell you what. Let's make it 200, and then we'll capture the other parts of that over some time, either in a milestone or just spread it out over the next 2 or 3 years. So I don't mind dividing up the license fee in creative ways that help them out. The royalty on sales, I always like percentage of net sales because then the marketplace really allows us, that's what determines the value of the technology. Milestone payments, as I mentioned, it's a great tool for assuring diligence, and it shares the risk, as I pointed out, and a minimum annual royalty, the price of exclusivity. Sub-licensing rights, revenue sharing, we could talk about this all day. This is, as I say, this is a really powerful mechanism, especially for those of us who want to see our technology spread around the world. I can go to a company if I put in the right provisions of an exclusive license, and I go, well, you're not really doing anything over in this country, and yet you've got rights. Yeah, well, I'll tell you what, I'm going to give you a year, and you're going to figure out how to enter into that market. If not, I'm going to have to either take it back, or I will give you or go sub-license, and we can share in some way. So it's a really powerful tool. Future IP, as I say, can be very significant. All IP costs, I think, if you got to grab all the IP costs from your exclusive licensee to help support your TTO. IP enforcement, we're not going to talk about that today, or transfer of license to third party. All the components should integrate, okay? How many of you heard of the zoom in and zoom out approach to design? You ever heard of this? Okay, so I thought I was the one that invented it. And then I didn't call it zoom in, zoom out. I just called it, getting into the detail and then backing up and look at the larger picture. And then I read it in Steve Jobs' it's referred to in his memoirs. He was an advocate of zoom in, zoom out. And license designing is perfect opportunity for zoom in, zoom out. So what do we got here? Do you know what this is? Look familiar? Your car used it today? It's transmission, right? So this is the license agreement. And guess what? It's got all these different moving parts. The key take home here is these things are integrated. Okay, now by zoom in, zoom out, I mean, you'll see me talk about this later, but this will be, say, royalty rate, and this is license fee. They're integrated. They're not separate. And when you're zooming in on royalty rate, is it going to be 5%? And we'll talk about that to the extent. Have you guys ever had to determine a royalty rate in a license? I know some of you, I'm sure, have. And there are some approaches to use. You take the price that the licensee, and you say, what are you going to charge for this? And they'll give you a price. Again, you're going to ask them for information. That's what we do as designers. We deal with the facts. How are you going to price this? Okay, fine. What is your cost of goods sold? Well, we're going to make some projections about that. What does that give us? The price minus the cost of goods sold. That's gross profit. And then there's something called the Goldscheider rule. You ever heard of Goldscheider rule? Goldscheider rule says the owner of the patent that enables the product, 100% enables that product, deserves 25% of the gross profit. Now, it's a rule of thumb. It's a very interesting exercise, and you both, this is part of the dating and rapport building. Let's do a Goldscheider approach. And you sit down and you get deeply into, because then you learn about their manufacturing, and you go, look, you've got to tell me this, because otherwise I can't design a fully functional license agreement with you. So, okay, well, let's talk about pricing, projection pricing. Let's talk about cost of goods sold. Let's make some estimates. And then let's try the Goldscheider. The point here being that you can get into real detail. And sometimes we do, sometimes we don't. We can get into real detail just looking at that little cog. But we got to remember that that little cog is interconnected, is meshed with this bigger cog wheel, but frankly it's part of a bigger system. So that's when you step back. And this is one of the things I would do. I figure out different ways to, term sheets are good for this. Term sheets are a really great design tool because it allows you to see those key points, and not only as they are now, but also think about them over time. That's where you start, you sit down and you go, okay, with my term sheet, I want this much money up front for my license fee. I want a milestone payment in year 3, and a minimum annual royalties are going to kick in at $50,000 in year 4. So what I have now is not only the amounts, but when they kick in. So I've stepped back and I kind of see the whole picture. So you go into the discussion, the design, with this, with the big picture, as well as, don't get stuck in the little details. You got to do that. You got to zoom in, but you got to remember to step back and zoom out. Okay. So you as the licensed designer, all of these are, ideally, they all work together beautifully in what I call this this nice little Swiss watch. And so you use all these different mechanisms, the upfront fees, milestone payments, et cetera, you establish your valuation assumptions in what I call the pre-negotiation valuation. You know, go in with an opening position, I will sometimes say, here's the license fee that I'm looking at right now. I'm not stuck on it. We never do this. We never go in and say, 250,000 license fees, 7% royalty. Take it or leave it. I don't know if you've ever tried that and it worked. Good for you, but that's not my style. My style is, this is my opening position. I've made some assumptions. Let's talk about them. Let's get to know each other. And, frankly, it might go higher. But it also might go lower. Let's talk about how we get there. We justify them, and I'm prepared to modify them in a professional dialogue. And I'll just say this one other thing, too, about being a designer. This is a reflection of dozens and dozens of negotiations. Sitting down with someone who's a professional who isn't emotional, other than, they're passionate about what they do, and they want to do a good job. They're fact-based, they're based upon as much reality as we can generate. And then you sit down and you have this intellectual work back and forth. And I'll never forget one of my, he became a very good friend of mine. He was the vice president of a big company. And we sat down, and it took us all day, face to face, and we would sit down and we would talk about all these elements. It was, the technology was a 2-photon scanning laser microscopy, now licensed to Zeiss, if you know Zeiss. Now a working tool for a lot of biologists around the world. Anyway, we would sit down and we would have these really intense, they're not negotiations, yes they are, but I thought of them and still do now as, this is design work. Like, wow, why that? I don't know that that's going to work. Well, what, So we have this, and then every once in a while, so we'd go like really intensely for an hour and a half, 2 hours, and then all of a sudden, I'd say, are you going to go on a vacation this year? And he'd go, what? I go, yeah, I'm just, we just kind of step back. Yeah, do you guys normally go on a summer vacation? Where do you go? Yeah, well, we go to the beach. Oh, cool. And we would have like 10 minutes, 15 minutes of just, let's stop this for a minute and let's be humans. Let's just be normal humans interacting at a level. And boy, that just powered us through all that. It's challenging work. This is really, it's design work. It's like engineering, and yet you're bringing in, not only bring in technology, but you're bringing in IP and you're bringing in contracts. It's great, isn't it? So enjoy the journey. Enjoy it. It is, it will work for you. Consider you also want to step back and go, is there anything besides any of these things we've talked about? For example, we don't really do much. I did do some cross-licensing, but for example, we would get equipment. The licensee would go, well, we can give you a piece of equipment for your food science lab. Okay, well, let me see if I can't factor that in. Another little thing we used to do, for those of you at universities, I didn't actually get it in here, but it was in here. Getting some of my students, graduate students, hired. Okay, Cornell students hired by a licensee, that's a win. Did it actually get expressed literally? No, but it was in there. Okay, front-loaded versus back-loaded. Do you know what I mean? So you got a balance here, right? And talk about that.
One doubt.
Oh,
Dick,
yeah,
I was just thinking,
yeah.
would it be possible to take the next half an hour?
Okay.
Can you cover some of the slides on structuring license terms?
Okay, let's see.
Possible? Comes much later.
Yeah, why don't, so let me find that. Help me find that. But let me just say this, and then we'll move on to that. So, there's a fundamental point about thinking about the design of the license, and that is front end, or front loading, back loading. So you think about this, in this example here, upfront if we've got a big upfront, that's front loaded, right? Versus a royalty that's lighter, royalties are generally back loaded. Minimum royalties, other payments that occur later in the license agreement. So that's really one of the things that, it's a sort of a fundamental factor. Are you going to try to capture more value up front, in which case it would be front end loaded, or are you going to try to be a little lighter on the front end and capture more value later with, say, a higher royalty rate, higher minimums, and also the risk, right? So if you are lowering the front load, then you're taking over more of the risk. Okay, so that's really one of the fundamental things. I'm always like, well, where am I with this? Where do I want to be in terms of that balance? So let me see if I can we get to the slide, the number of the slide?
32.
Slide 32.
Yeah, like 31, 32 onwards. Yeah, you can see below. See the number on the right corner? 21.
Ah. And again, you guys will have these, yeah, there's no reason to go through all these. These are some of the key terms of license fee. And there's the zoom in, the royalty rate and license fee and the license 30, 31. Okay, so here's an example, all right? Simple example. We've done very simple. How many know what an NPV is, net present value? Okay, NPV is one of the, probably I'll call it the workhorse of new technology valuation. It's based upon projections of income. And so typically you can do it unilaterally, which I recommend you do. You go in and you understand, you make some projections about the market size and percent market capture, and you make some revenue projections. And I like to do this preliminarily, but I also like to then engage with my licensee in the discussion. Net present value. We're going to discuss NPV in the next session. So let me just say that you now have done some homework and you've got an NPV of $500,000. Okay, you can go in and say in your term sheet, I want $500,000 up front due on signing, or you can schedule it. You can do $100,000 due on signing, and then $100,000 each year for the next 4 license years. Or you can do scheduled, which like I said, I really like. 100,000 due on signing, and 100,000 due on first prototype, 150 on first sale. These are all, of course, to be designed to balance that risk. Okay. Okay, setting a royalty, the factors, gross profit of enabled product basis. And you can, talk about zoom in. We can spend a lot of time, and here's also a little trick of the trade. You can spend a lot of time focusing on what is the right royalty rate. Now, I should also say that everybody should keep their agreements as living documents. And I'm always open to a licensee that says, 4 or 5 years down the road, says, we talked about all these factors, pricing, cost of goods sold, etc., and the royalty's too high. Okay, demonstrate, document, justify that it's too high. And if you can, I'm willing to adjust if necessary. And I always joke with the licensees. I go, yeah, I've been willing over the years to, when people come back to me and go, it was just, we overestimated this, that, and the other, so the royalty's too high. would you lower it for me? Like, sure, I'm a reasonable person. But I've never had anyone ever come to me and go, you know, things didn't work out the way we thought, and could we increase that royalty rate? I go, yeah, that's human nature, isn't it? And they get the point. So, setting a royalty to factors, the gross profit of an enabled product, and we're going to talk a little bit about this enabled product. Very quickly, I'll just tell you what this concept means. Analogy. If you have a patent on the car, and you know actually there was a patent on the automobile back in like 1902 or something like that, somebody had a patent that kind of covered the automobile. But of course it's ludicrous now, no one could get a patent on an automobile. But just imagine a patent on an automobile, and if you licensed it to Tata Motors and they go sell a car, by the Goldscheider rule, you, as the owner of the patent, deserve 25% of the gross profit that Tata has made. Got it? Now, if your patent is for the windshield wiper, are you entitled to 25% of the gross profit of the car? No, clearly not. So that difference between a patent on the whole car versus a patent on a little piece, that's called the enabling value of the patent. So, you know, to be reasonable, you have to go, okay, well, let's have some understanding that, my patent doesn't cover essentially the whole thing. So it allows both parties to kind of equilibrate a little bit. But anyway, we like to use the gross profit on the enabled product, and we get that gross profit by taking the sales price, which they will give you projections of. And as I say, you got to give me this information. I'm not going to do anything with it other than to help you and I design this thing properly. I do like industry standards. I always go out there and go, I'll even ask the licensee, what's your standard royalty rate in the industry? And I go, I'm not going to be bound by that necessarily, but I'd like to know that as context. I don't want to be too far out of it unless I've got a technology that's really valuable. Right? Or maybe it's so flawed that like, okay, maybe it should be a little under. That's your judgment call. The Goldscheider 25% rule, royalty is a percentage of net sales versus fixed fee. I always prefer percentage of net sales because it allows both parties to share the reward as the market delivers it, as opposed to fixed fee, because fixed fees suffer from the fact that they don't float with market changes, etc. The Goldscheider rule, I mentioned this. There's the car versus the windshield wiper analogy, and I'm going to give you a couple of examples. And the Goldscheider rule is a rule of thumb. Like I said, I like to do it sometimes, go, let's do the exercise. Let's do Goldscheider. And here's a trick. And that is, let's really focus on royalty rate. And you sit there and you just, what's the enabling value? What's your cost of goods sold, et cetera. And we're really focused on that. And they think that's kind of the be all and end all. When really what I want is, I don't mind that royalty rate going, yeah, okay, so I'll agree to 4.5. What I really want to do is get them to agree to my minimum annual royalties down the road. Those are guaranteed payments as long as that agreement's in place. That gives you so much leverage and power. So this is just for you guys here. I'm not going to go out there because then I'm giving away one of my little secrets, which is, really focus on royalty rate and quietly over here go, yeah, okay, I can agree. And you can kind of almost slip in that minimum annual royalty payment of, $150,000 in year 6. That becomes huge down the road. And for a lot of reasons, not least of which, I can go to my staff, my contract manager, and go, okay, go to all of our existing licenses and tell me how much money we're guaranteed to get this year through minimums. And I go, wow. So that's a great planning tool. Some other factors, industry standard range, I mentioned the Goldscheider rule, which is a rule of thumb, business model of the licensee. I always go, okay, well, is that going to fit for this percentage of net sales? And sometimes licensee goes, no, my business model doesn't really fit. Okay, let's talk about that. I'm willing to adjust for your business model, of course. And we're looking at market characteristics. What are typical margins? Is it in the commodity farm products, or is it pharma? And I'm always going back and going, well, what's the value and the scope of the technology? And between us, don't we know that we got some technologies that are really valuable? They're so unique and they're so cutting edge and they're really got the potential to be really significant. And then we got some others that are like, oh, okay, I know this isn't the world beater. Okay, so you've got that to consider. And then royalty stacking. Some industries, you have, no, this is not exactly a great example, but there's like 250,000 distinct IP in here. And if anybody has to pay royalty, they have to pay a lot of royalties, So you have to, if you come up with an invention in this mobile phone space, you're going to have to accept the fact that that the licensee may have to pay royalties to others. So you may have this royalty stacking. So that's an effect we can deal with. Percentage of net sales, where both parties are sharing the market risk. It's linked to sales and profit margin, and based on business reality. I like to go through this process of fixing royalty, because it's part of that rapport building. We emotionally connect. Becomes a really useful thing as you go down forward, moving forward, and you're talking to your licensee and they tell you things have changed. What's changed? That I told you cost of goods sold. Well, gosh, we didn't realize that the machinery necessary to manufacture the product made with your technology, it breaks a lot. And so we've had to hire extra people. We have to have, it's an expense we didn't expect. Okay, so now I know that because we already had this conversation about cost of goods sold. So I like that zooming in enough so that, yeah, it helps the parties design it, but also building this relationship. And for building the partnership and the trust, industry standards as a guide, not absolute. And this is what I always step back and I say to myself, as well as say to the licensee, it's in everyone's best interest that I make you as profitable as I can. And the more information you give me about your situation, your industry, your company, cost of goods sold, your manufacturing, your distribution, all your issues, the more you honestly tell me about it, the more you and I can design a royalty rate and milestones and license fees that are going to make you profitable. You're going to make a lot of money on this, and I just want a little share of that. Yeah, okay, here's an example. How much time have we got? 10? Yeah. How many more slides have I got?
15 minutes and you have 35 more slides to go.
What did I tell you? It's like drinking out of a fire hose. You'll have the slides, of course. So here's an example. Maybe I won't go into so much detail with it. So you'll have this. I'm not sure this is something you're going to want to use in your discussions today. But here's that Goldscheider rule. And then here's an example where you have a patent that fully enables the product. And you have a $200 sale price and a $100 cost of goods sold. And again, this is what I argue you do together, licensee, licensor. And so what does that mean? You got a gross profit of $100, simple math. And the patent owner then, using the Goldscheider rule, deserves 25% of that, or $25. And so therefore, the royalty would be $25 on 200, which is 12.5%. So these are just different examples where you have where the parties agree on different enablements, enabling factors. Sometimes it's pretty clear. Your patent covers the whole product. And then other times, no, it's just a windshield wiper. Okay. So So you adjust accordingly. And this is just a framework to give you so that you know that this is a route you can take. I like to start oftentimes with the 25% rule and adjust according to the enabling value. But then, you don't say, okay, we've come to a conclusion that it's 7.89%. Of course, we don't do that. We just round up or down. I usually like to round up as the licensor. So it's a good rule of point. Percent royalty can remain constant over the life of the license, or it can increase over time. There's arguments both ways that a royalty should increase over time because their profitability is going to increase over time, because their efficiency is increasing over time, their market share is increasing over time, that sort of thing. It can decrease because they'll say, well, the competition I'm going to have to endure. These are kind of outliers, I would say. In my experience, most of my licenses, they just stay constant. But we almost always put in a clause that says that the parties can engage in discussions about adjustments, and the licensor is willing to consider, not automatically agree to, but willing to consider adjustments to said royalty rate if the licensee can provide documentation and arguments to justify such adjustment. Or you can be creative. And as I say, be creative, but no more than you have to be. No more, no less. Scope of the license. So these are this is where it starts. Is it going to be exclusive, non-exclusive, co-exclusive? Could be time limited. I know a lot of you like to use the time limited. We do not use time limited. Ours are almost always for the life of the patent. What is the field of use? It might be, it might be something that's really a large market, or maybe it's a smaller market. So obviously that's going to affect the design of all these terms. What's the territory? Will they be all commercial use rights, which is the typical, or manufacturing only or sales only? One quick thing I want to point out is that I used to think this until somewhere along the line I went, wait a minute, I'm really limiting myself. And that is, normally what we grant a licensee is the right to make, use, and sell, and have made. And I was like, yeah, so my licensee is going to make and sell. So I'm looking for licensees that can make and sell. That's their business. So if I have a widget, I'm going to go talk to the widget manufacturers and sellers. But what I neglected to realize is that my license also includes the right to have made. So they don't have to make it. They can have somebody else make it for them as long as all the production is handed back to the licensee. So it suddenly opened up the possibility of licensing all kinds of different companies in the value chain. Now I think there's a story that I guess everybody got sent the list of different cases. So you have that, and on Friday I can talk about some of these stories, and one of them is a story that really opened my eyes about this. Like, for years and years, we all went and licensed this type of company, and then I stepped back and went, oh, wait a minute, maybe I can give more value to some other entity in the value chain. So it just really opens up a lot of creative options for you. And sometimes you can get really creative and give only manufacturing only, or only sales. That can be done, but normally you grant them all rights to make, use, and sell. There are some variations to royalty. There's per seat or per site. You see that with a lot of IT, fixed with periodic pre-agreed adjustments. All these things are possible. And milestones. And these are some more details on how you arrive at. We've talked about milestones. I use it we both agree on the development plan, the timeline, the TRL. understanding their hurdles and their risks. And at key de-risk events, a payment is made. That's how I design the milestone payments. I like time-based. They're not as good at sharing risk. Minimum milestones, really one of the most powerful tools for value capture. If you try to, like I said, if you try to capture all your value up front, you're going to have tough negotiations. It's going to be really hard to extract all the value you want to get in your license fee. But if you put it into minimums and milestones, it gets a lot easier and also really powerful for risk sharing. And these minimums and milestones become really important for licensor control. And I've been doing this long enough so that, yeah, you do a license agreement, hey, that's great. And then it takes on a life of its own, kind of like a marriage. And 5, 6, 7, 8 years down the road, things have changed, and now you need control for one reason or another. And these minimums, the payments they have to make you down the road, become a really powerful lever for you to do all kinds of things. So this is a really powerful tool.
Can we change the timeline for milestone payments?
Change the timing for
What is agreed in the agreement?
Could you change them later? Sure,
That-
you could. Why not?
If the who got the license, they're asking, they have the there is first they don't want to pay the milestone payment, but later agreed we want to pay, but more increase the timeline.
Everything is possible. So this is another thing too, and again, this is this is the reality. You have some licensees that you trust with your wallet, and they're just trustworthy. You've built the trust, they live up to it, both really good part. Then you have some other licensees, like you don't trust them. They're a little bit like humans. Some humans you can trust and others you can't so much. So I would say if it's I'll be open-minded to any licensee, but certainly if it's one that I trust, it's like, yeah, what's the issue? Wow, let's talk. What do we need to do to make, I've had companies, to this day I get taken to lunch for free by a CEO of a company that I was willing to change the terms so that his company could survive. Why would I terminate him? They provide jobs. They were a spinoff of Cornell, and they have 170 jobs. And I had the power to terminate and go find somebody else. Why would I do that? And so I gave him a break. He needed to adjust. Okay, let's talk about it. I gave him the right to do this, that, to defer, to do whatever. Turned out well for everybody. That's professional judgment. You're going to have to make a decision. But if it's one of those that you don't trust, you want what? I'm not sure I want to do that, So I'm not a pushover, but I am a reasonable person. And we strive really hard to be good partners. The word went out around in our circles. People got back and said, Cornell is a great partner. And I love that reputation going around. Cornell is a good partner to work with. We're not always easy, but we're reasonable. Okay? So I'm always willing to listen and to try to be a good partner. If they need to make some adjustments, I'm willing to do that. Talked about this time-based minimum annual royalties based on technology and business reality, based on the parties' agreement on the development plan and timeline, based on sales projections, both timing and amounts of the licensee. It's this economic teeth of the duty of commercial diligence. That's how I keep their feet to the fire.
Yeah, I have one question. We have technologies which are process-based,
Okay.
environmental engineering processes,
Okay.
setting up of STPs and WTPs and all. So in that case, how to fix the royalty? When we are giving the...
On a process. Sometimes it is challenging, maybe it's on a per, it could be on an annual, is it is there a flow? Did you say, you said environmental engineering, are we talking about a flow?
It's just that the flow
Yeah.
of an effluent.
Yeah, it's a fluid.
So there's no product or
Yeah.
any money there.
But it's clean water.
Yeah.
Yeah, it's
So
a,
maybe it's
It's
gallons.
a treatment process. It's not a treatment plant. That is the process.
I mean, we want to be creative with it. And sometimes there are ways that I think it would be ideal. Like, well, yeah, why don't you just give us let's peg royalty to the, let's say, gallons treated per month. I don't know, something like that.
So the general principle is whatever. So if you're selling a product, right, you can you can understand what the earnings will be there. In the case of effluents, it is what is the cost of treating that effluent or disposing that effluent that you're going to incur. And
Yeah.
by having your process, what did you save?
Right.
And then on the back of it, you do your calculations.
Yeah, the savings, and I love those.
Yeah.
When you have a savings, your technology enables a savings, and you quantify that, and then you go, okay, let's talk about some percentage of that. Yeah, I wish I had more of those. They're great.
Can I just request, many agreements in India, they don't use minimum annual royalties. So it's a good idea to discuss this.
Okay.
And also a few slides you have on future IP issues relating to that. So I think this is worth talking about, especially the next point you.
Okay, so this is worth spending a little more time on. Our exclusives almost always have minimum annual royalties. It's a hugely powerful tool for a variety of reasons. Okay, so we sit down and we agree on what the development timeline is, what the plan is, how much they're going to invest. Bottom line, when are you going to have that first product sale? When are you going to have it implemented? Okay, and then we've made projections together of sales and therefore what royalty income we should get. And based on those projections, we make an estimate. And this is the way I do it. I'll go, okay, you've projected that you will have sales in year 4. You've projected, and here's another thing, is that I go, well, we're looking for a good partner here. Do you think you can generate sales with this? Well, yes, I can. Kind of give us a sense of what is your expectation of sales of the product. And they'll tell you, and we go, okay, that's a good set of projections. You've projected to sell $1 million worth of product, and we have a 5% royalty, so that's $50,000 you owe us. Okay? So here's what I do. Because I'm generous, like I said, my style is to be generous initially, and then I get a little harder as time goes on. But I go, okay, based on your projections and our agreement of royalty rate, you should pay us $50,000 as an upfront minimum royalty at the beginning of year 4, license year 4. But I'm going to give you a year where I'm not going to charge you that minimum. Now, they still have to pay. It doesn't mean they don't have to pay. They have to pay royalty, but they pay it at the end of the year and they do the calculation, whatever it is. So I'll say, all right, I'm going to give you, beginning with year 5, that's when it starts. And they're like, oh, he is generous. Okay, I'll agree to that. I don't think I'm giving up all that much, so I will do that. Now, the other thing is $50,000. Here's the other thing I do, is I go, based on your projections and our agreement on the royalty rate, you will owe us $50,000 at the beginning of year 4, and you've projected that at year 5, you will owe us $75,000 because you've increased your sales. I'm not going to ask you for $75,000. I'm only going to ask you for $50,000. And they go, wow, this guy is so generous. So, I back off because it works, and we're going to cap. So they still have to pay royalty on every single sale, so I'm not giving that up. It's not like I'm saying, yeah, royalty free. Not at all. I just don't use this mechanism of they have to pay a minimum annual royalty at the beginning of the license year before they've had a single sale. And then the year goes around, and then there's a calculation. What did you really sell, and what do you owe me? And if you owe me what you prepaid, you're good. But if you've sold more, you owe me that difference. But if you didn't sell enough, you have to eat that difference. And so what happens is they have to like, okay, all right, let's get going, everyone. We got to go sell this. We got to push it. It's such a motivator for them to push your technology. And then once you have that leverage, then you can do all kinds of things with it. Like, look, I've got some other companies here that have been knocking on the door that want to have a sub-license. So I think it's time, and they'll be like, oh, no, I don't want to do that. Okay. Well, you've got another big payment coming up, and I tell you what I could do, though, if you'll sub-license, I'll lower that minimum just a little bit for you. So you can kind of adjust moving forward. So I really like this minimum annual royalty payment mechanism. Yeah.
What is the time frame for this royalty? Say, suppose for 5 years we would be charging this royalty, or 10 years, 20 years?
The life of the patent.
Yeah, but like in automotive, like technologies are changing, like in 5 years it will be...
So the way I handle that is I say, typically, let's say it's 5%. 5% over the life of the patent. And it doesn't change unless, because you've just said that there's some market change, there's technology changes. If that's true, I put in a mechanism that says that if the licensee can come in and demonstrate with documentation and an argument and whatever they need to show me, look, there's so much competitive pressure. We're losing market share, this, that, and the other. Please reduce that royalty rate. It's the only way we could continue pushing your technology. Fine. I'm open to that. So yes, I would do it.
Yeah, but my understanding, TT can happen without a patent as well, right?
What can?
Means technology transfer can happen if there is no patent as well.
Well, what are you licensing?
Suppose I have a technology which is not patented yet.
Yeah.
But there is a license interested to...
Well, so I always go back to, what have you licensed?
Maybe the know-how he's talking about.
Maybe know-how, or it is not patentable. Means.
Well, yeah. So, okay, let me just say this right now. I never license know-how. Why? Because I have no control. Who has the know-how? Me? The tech transfer office? No. Who has the know-how? Who has it? The inventor?
Yeah.
Right. So you're going to rely upon the inventor to deliver the know-how. And know-how is way too ambiguous. Trade secret's another thing. We can talk about trade secret. That's an asset. Know-how's not an asset. Know-how is way too ambiguous. And I don't have the ability to control the inventor. So I never put it in. So it's just not something that I can use. We never use know-how. Patents, trade secret, the more and more I go down the road, trademark. So I used to be like, well, why would we ever have a trademark? You just get a patent and trademarks, who cares? Well, good example. Well, classic Coca-Cola, but how about, did anybody know Gore-Tex? Ever heard of Gore-Tex? You guys don't know Gore-Tex. It's famous in the US, still is. I mean, so Gore-Tex, I'll just tell you what it was. It's a patent on a fabric, on a material, and it allows gaseous water to pass, but liquid water can't penetrate. So it's great for athletic gear. Great for outdoor gear. As an outdoorsman, I loved it, right? Gore-Tex, the patent expired, 20 years after filing. Gore-Tex still around. trademark.
Okay,
It's still
in
around.
case we consider 20 years.
20 years from the date of
Yeah,
file.
but calculating the sales projections for 20 years, isn't it like to calculate the royalty rate or to calculate net present value for next 20 years?
Detail about net present value. I normally don't go more than 10. I usually do 7. Because beyond that, it's like, wow, real crystal ball, you know? Like then I bring in, you know, like the soothsayers. It's just too unknown. 7 years is what I go with primarily. But so know how we don't do it. Trade secret is great if you can do it. We have a philosophy in practice. We don't do trade secrets at U.S. universities.
Richard, can we just wrap up in 5 minutes?
5 minutes.
Yeah. We're
sure.
running late. I have a few questions. Maybe over tea I'll ask.
Okay, let's see what's the minimum annual royalties. There's more details for you. The sub-licensing right details, future inventions, some things to think about, IP costs and enforcement.
Can you focus on future inventions?
You want to look at future inventions?
Because nowadays we are getting like licensee always wants to own solely the improvements done by him.
Yeah, so, it goes back to what your IP policy is. And I'll just tell you, and I had a strong debate with my 2 colleagues because they've heard me say over and over, public sector research institutions should never sell their patents. They should never sell their patents. And I'll go to my grave saying that. And they go, well, but that's not reality. We have to be willing to bend. I don't care. I'm not going to bend on that. We should not give up ownership. So that's where I come from. So here's what I do, is I say, okay, you've licensed. Now, if an invention, ownership is tied to inventorship. That's our policy. So if there's an invention made by our people, Cornell personnel in the course of their duties, even if it's through a research contract, then the question is, if that future invention falls under that umbrella, remember I talked about the license umbrella? Let's say it's a license to automobile windshield wipers, and an invention comes out that the invention is a spray that allows the windshield wipers to get washed. Well, maybe that's within. So I'll just let it flow in, and that's what we would agree to. We would just add it as a list on the list of IP, licensed IP. But if it's something completely outside, if it's a new, a radio antenna, is that old-fashioned? A radio antenna, it has nothing to do with windshield wipers, then it's a separate negotiation. That's the way we handle it. Now, if they are co-inventors, which can happen, they're co-owners. Then things change.
I mean to say, like, suppose I'm giving some algorithm or source code.
Yeah.
And they are going to do any modification.
Can I request, can we just,
Questions,
you can,
yeah.
That's the important topic.
discuss over tea. I would, yeah.
Okay.
So we are facing a lot of,
Okay.
Because
negotiation, we are facing these challenges.
Yeah,
we have
yeah.
another important topic coming up on valuation.
no, over tea,
So,
Richard,
yeah.
will maybe you can speak to him for a couple of minutes because I need to explain the case study
Okay.
as well because
Sure.
we may not have time to do it right now. I'll have to tell them to go back and
Okay.
get the sheets.
So one thing I'll just add here to kind of give you something to be thinking about, and that is there is a provision that we rely on, which is anything that, like for example, we do it with biological materials, but you can also do it with algorithms, where you say, okay, the algorithm, and algorithm is a good example where it can be trade secret, can be maintained as trade secret, and your licensee is supposed to keep it secret. Anyway, what we would say that any invention, if we hand over our secret algorithm, or if we hand over to you our biological material, any invention you make with it, which could only have been made because you had that algorithm or that biological material, you're the owner, my licensee, Why? Because you invented it, we didn't, you're the owner, but you can't do anything with it without written approval from us. So it locks us in together, we then have to negotiate. So we use this mechanism where they can't just run away. Thanks for that algorithm, and take off. They still have to come back to us. And we're reasonable. You've heard me. I'm not an unreasonable person. But we have to protect our interests if they are taking our algorithm, if they're using our biological materials. And if our people invented it, then it's another story. We own it. Full stop. Now, there is a complexity here that under the consulting, sometimes faculty with that licensee can go over and they invent something, and it's a gray area where some of their inventions in their consulting role will be owned by the licensee. And other things that they invent will be owned by the institution. So therein lies some opportunity for a little confusion. You have to be clear how you define that. You'd have to define that in your agreement. And we've done that. And you try to define it clearly before you have the problem. So, wow, thanks everybody for being willing to drink out of a fire hose this morning.
Thank you, Richard. So I request Pradnya now to quickly explain the case study, and then we move on for our tea break.
So I'll just quickly explain. I know tea is waiting outside. The intent of this exercise is basically, now you've heard Richard about the licensing structure and the agreements, how they go. So we would like you to understand the deal structuring process through this case study that we are giving you. You will understand how to structure the licensing terms. Now you have understood various terms of finance, basically annual, minimum on annual royalties, so on and so forth, and how to structure the financial terms as well. What is available to you, I'll explain you. There is a case for which a preliminary licensing terms have to be structured, and we have given you a term sheet template, and it has certain appendices also which carries information about what is being transacted and territories and few more things you can just go through when you have time. And what you need to do is you need to discuss within yourself, the table participants that are with you, and propose key aspects of the licensing deal structure. So the below thing right now, we don't have that luxury to spend that time. So about party 1, the licensor is an academic institute. I think ABC Institute we have christened it. Party 2, we were planning to have a licensee as a big company like Pfizer, and we wanted to request you to have similar kind of term sheets developed for a medium-sized company, that is Glenmark, and probably for a startup, but we may not have time. So we'll request you, at least you come prepared tomorrow with the Pfizer kind of a company as a licensee, right? So what is the technology package? It has a patent, and the priority dates and rest of the things and claims are given. And preclinical data from the licensor is available to you for doing the term sheet. So products are API and formulated product comprising API. There could be fields of use, treatment of prostate cancer, but the drug can be used for treatment of other cancers as well. So that's the basic structure of what the case is about. So motivations to do the deal structuring, you need to understand what are the motivations of each party, licensor as well as the licensee. So kindly give attention to the motivations. First is an impactful drug in extensive use globally. Credits as originator. I think from licensor's point of view, the second point is the most important. Give more, I would say, weightage to that in your motivations. And financial returns, that should not be a governing criteria for doing your term sheets structuring. Motivations of party 2, that is the licensee, new markets, market share in existing market segment. The second point again here should be the motivation, the major motivation for the licensee. Higher profits, maintain profit levels, overcome IP barriers if there are any, create IP barriers for others to get a competitive advantage and edge over other competitors in the market, extend IP protection and option to play the game if needed. Yeah.
Okay, just go back previous one. Yeah. Please note that as an academic institution, primary goals might be these two, not this. Okay? You might have a different view, but I'm just trying to tell you that that is the what they're really, many of them are looking at. The second, from their point of view, this party 2, it might change depending upon which kind of party you're dealing with. Okay, so please understand, think through that, because you as Richard said, you want to tailor it for a win, right? For the that it is successful at the product, the market. They would want to see, everybody talking about in the newspaper that this is, say, a technology from NCL. You understand? That is more more important for them, and not necessarily some tech transfer fee that came in between, right? So if you want it to succeed, how will you make it succeed? And if it's Pfizer, the priorities might be this one, market share in an existing market, because Pfizer might have already a product in that space, right? And might be running out of patents coverage. Whereas if it's a startup or somebody else or a Glenmark, it might be very different. Okay, so understand that before you structure the deal. Okay, and then you go and structure the deal. Go ahead, please.
Yeah. So basically, you will have to consider these issues, which you can see on the screen. What is the IP scope? What is the life, coverage, strength? How the licensee will use the IP, scenario building for life of IP. How the industry works. For example, what happens when generics enter? You may have to think about that, simulate it, and get all those things in your term sheets as well, foreseeing what will happen in the future. So task cut out for you and discussion purpose, and when you do the exercises, to maximize chance and scale of success of the licensee, as Dr. Premnath mentioned, and reasonable financial return. You should not try to, have focus more on maximum financial returns. It should be a reasonable financial return, right? And plan for fail safes. What if this happens? Fallback options, what you should have in mind. So, you want to add something?
Yeah. No, it's okay.
Yeah.
So the rest of it is about basically thinking through that sheet which is there with you and thinking through it. It's a sample term sheet. We just wanted to show you that. And thinking through some of these terms, and the next page which has other terms as well.
So you can think through these. Yeah. And financial arrangements, we don't want actual numbers here, but you should be able to write X% of what, those kind of things. Do not write actual numbers, but just think through what will you propose as upfront fee. Let us assume that rupees X is the upfront fee, rupees Y is milestones. How many milestones? What will be the milestone? As Dr. Richard was mentioning, there could be time-based milestones, or you are achieving a target, those milestones. So think through all these and come prepared with the term sheet. We'll collect those tomorrow. Write all 3 names of the discussion, group, and we'll collect those, and we'll go ahead with that. I don't know whether we'll have time to discuss that in person, but let's try to
do it offline.
Yeah.
Okay. Some of you who are from the drugs business might find it easier to think through milestones and all, but you have to also think through a little bit of the industry, how it works, in order to actually be able to say what can be the milestones, or should there be milestones. How do you? So just to give you a sense of it, one new drug to market, okay, the number, and you can find data on this online, okay, it costs you about $500 million. Okay, so Pfizer is going to invest $500 million, roughly, in, say, and 70% of that will go in the clinical trial stage. Maybe less than 30% will go pre-clinical and so on, getting till the right. So that's just to give you a sense of it, okay. And now you need to think through it, right? How do I structure it, right? What do I do? Okay. Okay. So I think we'll stop here.